Let's begin today from the court because it has been a very busy day there with 3 different cases taking center stage. From the Supreme Court first, where the EC has been ordered to provide collation sheets to political parties, and also we know that in the High Court, the NDC's case challenging the NDP's case challenging the disqualification of the party flag runner Kunedu Ajimang Rawlings being struck out by the High Court. We'll bring you those details in just a moment. But first, let's start with the Electoral Commission and the issues to do with the suit that was filed by a citizen of the country about the collation forms and its details. Let's begin with that. Joseph Akabule covered that for us in court. We'll start the discussion right about now. Joseph, good afternoon to you.
Good afternoon, Francis.
Let's begin with that case on the collation forms. Give us the background to the story.
So the private citizen filed the suit, that's Kwesi Nyameti Association. He filed a suit at the Supreme Court asking that the court compels the Electoral Commission to provide a coalition sheet for the presidential election to the political parties and their agents at the close of polls. Now we are talking about 275 collation sheets. Now the collation sheet is a document that contains the results from each polling station within a constituency. Now he argues that if you look at the Constitution, it calls on the Electoral Commission to organize elections that are transparent, free and fair, as well as credible. Now he's saying that if those sheets are not provided to the parties, it makes it very difficult for someone to challenge the results, because the collation sheet is a document upon which the Electoral Commission chair will be declaring the final results. Now that document, he says, cannot be in the custody of just the Electoral Commission, so that if as it were someone has challenged with the result that has been declared, how does the person know which document on which basis the EC decided to declare as someone as the winner of the polls?
Okay, now that was just one part of it, because I know that the matter of where the signature comes on that form also was part of the release being sought by this plaintiff in court. What was the determination on that score?
As it stands, the collation sheet doesn't even provide for party agents to sign, unlike the polling station results sheet that provides for political party agents to sign as well. Now the court again ruled on that score that that column should be created on a form and parties agents should be allowed to sign as well. Why
has this become important? Because many will ask, yes, collation form is good for the elections. Why has this become a big legal matter that we are having it dealt with at the Supreme Court today?
It has to do with the 2012 election, and during the proceedings, one thing that lawyers for Nana Akufo-Addo, who was the lead petitioner in that particular election petition, he was asking for that document from the Electoral Commission. He wanted to add it to bolster his case, but unfortunately the Commission didn't make that document available. Now following that, the Electoral Commission set up a reform committee that recommended that that document should be made available to political parties. Now interestingly, looking at the current regulation, the CI, it allows for the document to be given to the parties in terms of the parliamentary elections, but it doesn't make provision for the presidential election. So that was what led to the gentleman going to court to find that order.
Now, ironically, the one who was part of the 2012 election petition, one of the lawyers, in fact, Mr. Akoto Ampao, is the one who's actually the lawyer for the plaintiff in this case, isn't it?
Yeah.
Exactly. So today, per the ruling, when is the EC supposed to do this, considering the amount of time we have to the elections? 40 days to go.
One point that Justice Atugua made is that looking at the arguments put forward and comparing it to the CI, they've realized that there are lots of inconsistencies in the CI. So they first directed that the lawyers on both sides, Thaddeus Sorry for the Electoral Commission and Akoto Ampao for the plaintiff, they are, as it were, in a meeting as we speak now, and they are to have a look at the arguments they presented, identify these inconsistencies, correct them, and present a draft of a sort back to the court to have a look at it. And now if the court is satisfied, the court will rule on it just today, again confirming that this is the new way the law should look like, and it becomes law now for the country.
Interesting. So that will mean that on the matter of the collation forms, whatever is agreed between Mr. Sorry of the Electoral Commission and Mr. Akoto Ampao for the plaintiff, that becomes the binding document that will supersede what is already in the CI that takes care of the collation forms and who receives it, the column for signing. Is that what it is?
Exactly, but it deals more with the drafting, the language, because if you look at some parts of the provision, it says you can provide for the parliamentary but don't provide for presidential. So they are just amending those clauses and I'm ensuring that it fits overall into the entire provisions in the document. So they are going to present it back to the court to have a look at it, so that the court could have done that on its own, but the court feels that the EC is a stakeholder, same with the party, and the court agrees that indeed there are inconsistencies, but they want the two parties to come with a draft document for the court to have a look at it and then decide that this is the law now.
Now this raises a very central point about the work done by the by Parliament when the CI appeared before it, because if the law, as we are made to understand from the Supreme Court, has some amount of inconsistencies, then we begin to question the work done by the committee that looked in the CI before allowing it to mature in the 21 days by Parliament. We'll get into that leg of the conversation in just a moment. But Joseph, you spoke to the lawyer for the plaintiff, Mr. Akotampo, right after the proceedings today. What did he have to say about today's ruling?
Obviously excited, a ruling in his favor, and he makes the point that he thinks it is one that will ensure that this year's polls is free and fair and as well as transparent.
Let's hear from him now.
Our point is that because the law didn't provide for the signatures of the returning officers at the Constituency Collation Center and the candidates or their agents, any form could subsequently be changed and they'll fill in these are the results. So the signatures are to authenticate those documents, and the Supreme Court granted those orders. As regards some of the confusion in the drafting, the Supreme Court directed that all the parties, they recognized that there was clear confusion. There's clear confusion in the drafting, but their view was that these are drafting errors that can be corrected by the court. And the court has directed that we, all the parties, meet and work out the corrections and report back to the court so that it can, then the court can rule on it, and then that becomes the basis for the conduct of the 2016 election. So I think that all Ghanaians should be very happy that we are moving towards an electoral process that is free, fair, transparent, and credible. No, the copies of the collation sheets, this is also very critical, will be given to all the parties, both for parliamentary and presidential. The important thing is that if the parties or the candidates have copies of the collation sheet results and they have copies of the polling station results, they can easily check whether what is recorded in the polling station results is what is on the collation sheet, and therefore what is transferred to the EC at the head office for the presidential election is the correct one. So this is a very, very important decision of the court, and I think that Ghanaians should hold high the Supreme Court for coming to this important decision.
Now, as we indicated, there's a meeting ongoing between the lawyers for the Electoral Commission and that of the plaintiff. That the lawyer for the plaintiff is who you just saw, Mr. Akotampo there. We'll try and get you an update on what has been agreed at this meeting, which we're learning is ongoing. We'll try and get you some more details here on the show. But let's move from the Supreme Court and drive down to the High Court, because another case came up today, and that involves the flag bearer of the National Democratic Party, Nana Konadu Agyeman Rawlings. Well, we know that after the EC announced about some weeks ago that she cannot contest in this election because of some issues on her nomination form, she took the matter to court, challenging that decision by the EC. That played out today in court. We're learning that the suit that was filed against the EC has been struck out. Let's get more details now. Joseph, what was the legal basis or the ruling for which reason this case has been dismissed?
What's happened is that at the very first hearing of the matter, the lawyers for the Electoral Commission raised some preliminary objections. Now, they are saying that the procedure used by the lawyer for Nana Konadu Agyeman Rawlings was wrong. They are saying they should have come by a petition rather than coming for a judicial review. Now, the interesting thing about the NDP suit is that it's not just a judicial review. They are also asking for an enforcement of a breach of fundamental human rights. So it's a two-in-one suit that they are asking, and that is the title. Now, those were the two main objections that a lawyer, on behalf of the EC raised in court. Now, the judge in the ruling says that it's not possible for you to ask those two as your title matter at the same time. So it was because of that that the court decided to strike out the petition entirely, the suit entirely, describing it as incompetent to, in the first place, invoke the jurisdiction of the court. Interesting.
Now, just suppose that what we know with the PPP and their case, they went in with a certiorari and not an election petition. That also was made to stand with. We know the ruling will happen tomorrow. Right. We'll get those details. But Joseph, staying on this case with the NDP, we understand that the plaintiff in this matter, I'm talking about Nana Konadu Agyeman Rawlings, is supposed to pay a certain fine. How much is that?
It's Nana Konadu Agyeman Rawlings and the party. They are supposed to pay 10,000 cedis to the Electoral Commission as cost because when the EC lawyer made the argument in court asking that the matter be struck out, he again mentioned that they should be awarded cost because if you invoke the jurisdiction of the court wrongly and you've asked the Electoral Commission to come and waste its time in court.
So 10,000, do you know whether it has been paid?
We don't know that for certain.
Okay. Now, any idea what the next line of action is for the NDP flag bearer? In
fact, one point that the judge made as he delivered that ruling is the fact that the door is still open for them to come in if they want to come in. And at that point again, lawyer Asan Kumar representing Nana Konadu Agyeman Rawlings mentioned that they will be filing later today. They'll be filing another suit. So we still have to check whether that has been filed. But we understand they are going back to court to challenge their disqualification still.
Okay. Now, we'll bring you a statement that was released by the party this afternoon in relation to this case. We'll bring you that statement in just a moment. We'll also try and speak to the lawyers for what action they have taken after what they heard today at the High Court. Yes, they've been fined 10,000 Ghana cedis, but we know the party still believes that they have a case for which reason they are pursuing other courts. Another thing happened, but we have to return to the Supreme Court for that because we know that Justice Paul Otoderi was also at the Supreme Court today. For those who may have forgotten, he is one of the justices that the investigative journalist Anas Aramio Anas filed a petition at the presidency calling for his removal for misconduct, among others. Justice Derry filed the suit challenging the capacity of Tiger IPI, the company Anas heads, to file the petition for his removal. Well, Joseph, what was his argument today for which reason he wanted the court to dismiss Anas' suit, and which reason the court gave for not granting his request?
The point he makes is that the Constitution provides that a citizen may petition the President for the removal of any justices of the court. But he again argues that looking at the said petition which was sent to the Presidency, it is written on a letterhead of the Tiger IPI. And he makes the point again that Tiger IPI is one company that is not registered. You recall lots of dispute about the status of that company. Even former Attorney General Martin Amidu waded into that controversy. So he makes the point that that is a company that no one can identify. So that company is petitioning for my removal. Why should you listen to the company in the first place?
So the court did not grant that request for him, did it?
Exactly, and the point that the court is making is that even though there is written on a letterhead of Tiger Eye, if you read the content of the letter, throughout the letter they say consistently, Anas makes the point I, and they say once the I runs through, you know that it's not a company that is petitioning, but it's a private individual who heads a certain company. And the judge again makes the point that they are arguing more over form rather than the substance of the matter. And the substance of the matter is that someone is asking for you to be removed. So the letterhead and the title that appears to be that of Tiger IPI, it's not something that should really be the basis for your objection to that particular one.
Before we go to what is his decision, whether this matter is case closed or not, you saw him today in court, Justice Derry. What was he like?
Justice Derry is one interesting figure. I mean, and for those, just to help those who may have forgotten about him, he's the one who is caught on tape receiving a goat from one of the guys who came in to try and, get a case, a victory in his favor in terms of the court case. Now, he came in quite calm. And you know, that of the ruling of the election collation sheet, that was earlier than his.
Yes. So,
in fact, he was seated at the back, and once a while, he was communicating with his lawyers, passing comments about the case that was ongoing and waiting patiently for his as well. Okay. And once the ruling was given, there's an interesting way he often escapes the camera. When he's moving out, his lawyers take one route, he takes the other route. So it's often very difficult for him to be captured on tape.
So we didn't get him on tape?
Not at all.
Interesting. But has he given up in this case?
Not at all. In fact, his lawyer mentions, Nikpaku Ado, he mentions that the directive from the court rather gives them clarity because they are now certain, because he says in the trials of some of the other judges and during the hearings, you realize that they had to have about 3 persons who were all hooded appearing and presenting evidence. But this time around, they say that the court says it's Anas who filed it. So they are going to file another petition, and this time they want that single individual to appear unmasked because he as an individual filed a petition.
But does that change the details of the case in question?
It doesn't, but they said at least they know who filed the petition and they are going after him.
Let's hear from Nikpaku Ado now.
Very fundamental question that we've been posing since the beginning of the case. That was who the petitioner was. You remember that from the beginning there has been this confusion as to whether it was Tiger IPI or it was Anas Arimia Anas. And the implication had been that because allegedly it was Tiger IPI, there were at times 3 people who were taking part in the proceedings when it came to those judges that had undergone the first phase of the impeachment process. We took a different position, that it was essential, because of the confusion as to who the identity of the petitioner was, for us to bring it to the court, for the court to answer that particular question. So the court has answered that question today in very unequivocal terms, that the petitioner is no other than Anas Arimia Anas. So from henceforth, when we are proceeding in respect of the petition, we will be dealing with Anas Arimia Anas and not any company called Tiger IPI. The person who wrote the petition is Anas Arimia Anas, and that the court has confirmed today. So that is the
the sense that it means you are coming to court once again.
Oh yes, we are coming to court this afternoon. In fact, I have instructions to file in respect, because now we know the petitioner. You see, we were of the position that we needed to know who the petitioner was, because there had been that conflict between whether it was Anas or whether it was the Tiger IPI, and especially because he had written the petition on the letterhead of the company.
So that's Nikwapo Ado, he's lawyer for Justice Paul Otaderi. And as you heard him mention, we've not had the last of this issue. We'll begin to see some more details. And as they wish, we may see Anas alone walk into court. Will that be the options? We'll see in the coming days. But thank you, Joseph, for a wrap of proceedings today in court from the Supreme Court, the two cases, and also that of the NDP flag runner, Nana Kunedu Ajiman Rolex. I nearly said another name. But anyway, thank you, Joseph, for your time.